The jury in the sexual assault trial of 5 former World Junior hockey players has been dismissed. The judge did not give the jurors a reason for the decision. There was a previous mistrial in this case, which required a new jury to be seated. Well, after today, the proceedings will now continue as a judge-alone trial. So yesterday, a juror passed a note to the judge that reads, quote, multiple jury members feel we are being judged and made fun of by lawyers Daniel Brown and Hillary Dudding. Every day when we enter the courtroom, they observe us, whisper to each other, and turn to each other and laugh as if they are discussing our appearance. This is unprofessional and unacceptable. CP24's crime analyst Steve Ryan joins us live at the desk. And also, for more on the developments in London, we're joined by criminal defense lawyer Kim Schofield, who is joining us virtually. Kim, can you hear us?
Yes, okay. And hey, good afternoon.
Good afternoon. Thank you very much for taking time to speak with us. I want to start off with the content of that note. Multiple jury members feel we are being judged and made fun of by the lawyers. What's your response to that?
Okay, so it hits close to the heart for sure, because I'm sitting in that position at times, which is defense counsel. Now, I know the 2 defense counsel in question. I'm confident that this didn't happen, that they weren't in fact making fun of jurors. Why would you? You're trying to convince them of the innocence of your client. Why would you? Now, the issue, though, is the perception that it happened. So sometimes I think because we're in the middle of this, we see terrible things every day. We represent people charged with terrible crimes, and sometimes we're maybe approach it a little too lighthearted to the public perception. Okay, so it's not as though we don't take it seriously, but it is a day in your job. It's a work day. So maybe it's a perception issue as opposed to a factual issue, because I really don't think that they would make fun of the jurors, but they did feel that way. So that becomes the real problem.
Okay, and so along with that, CP24's crime analyst Steve Ryan and I, we were just talking about this. You know, your perception is your reality. How does that parlay? How do you see that as well when dealing with witnesses?
Well, so on that note, Kim, what struck me in that statement that was read was the as if, and I put that in quotes. And as you said, there's no evidence of that. That is a juror's perception. So if that's the case, how do you as defense counsel get around that if I'm looking at you or you're looking at me and my perception is that you are degrading me or making fun of me without any evidence to support that? What does a judge do next time around?
Okay, so the judge did the right thing, which is the jurors feel that way, and that's their perception is their reality. Now, the issue is, I think, for the criminal justice system is that we have to have a little self-reflection here, all of us, not just defense counsel, crowns, judges, everybody. It's a serious business, and I think it's not that they're not treating it seriously, but I think that you have all these other factors that play in too, which is a bit of maybe the vilification of the defense in sexual assault trials, because at the end of the day, you know, there's an attack on the complainant, and you know what? It is an attack, and it's an adversarial system. So maybe some of that plays in. Maybe also, you know, the jurors have to go through protesters every morning. So there's all of this that maybe plays into that, and there probably was some laughing by defense counsel, as there would be by the crowns or maybe the court officers. I mean, it's people's daily work, but you're quite right. The perception is the reality. So maybe we have to just keep that in mind more and more and more.
I was talking, we were talking with Joseph Newberger earlier on this morning, and we discussed how, as a former officer in charge, a Crown, you as defense counsel, all of us would be constantly evaluated by a jury. Whether I was giving evidence or not, if I was sitting with the Crown, I had to be mindful of the fact that the jury is watching me as well. So I think you raise a good point when you talk about maybe all of us forgetting about that these are jurors, and not only they listen to the evidence, but they're also watching the reactions of everybody involved. So you do think that everybody in the court process might have to kind of pay more attention to how they react in, or how they carry themselves in court, rightfully or wrongfully so. That might be the reality going forward.
So I'll give you an example, for instance, on a day-to-day. So I'm representing clients charged with very serious offenses. We win, they go home. We don't. The next 15, 20 years of their life is with Her Majesty. So very serious matter. Now, sometimes the crowns come in, maybe even sometimes the officers in charge. Less the officers, I have to say, but sometimes the crowns. You know, they're talking about their day last night. They're talking about, you know, water cooler talk, so to speak.
Right.
And I have had on occasion to speak to them and say, look, you know, I know you mean nothing by it, but this is a serious thing for my client. So sometimes we all have to take a just a reset on that. But it's not a coincidence that maybe it's defense counsel that are targeted here, maybe even more so because of the allegations, and because maybe the jury, well, not maybe, but the jury sat through 9 days of cross-examination. So they have seen defense, quote unquote, attack the complainant for 9 days. So they may be specifically sensitive to any action or perceived action by the defense.
Okay, with this move, does this ensure a fair outcome, a fair trial?
Yes, I think so. So Justice Garcia, a very experienced judge, she's already listened to all of this. She'll be able to, she's heard pretrial motions, she's heard evidentiary issues, which is what trial judges on judge-alone trials hear all the time in any event. Now, the Crown took the position that they are less, or that they are disadvantaged somehow by this because they prepared their case for a jury. Well, perhaps they did. I mean, obviously they prepare it for a jury because the jury was there, but not so disadvantaged that they can't do, you know, maybe they have to call additional evidence if they need to, maybe recall a witness if they need to. But all in all, I think that this is the right and fair decision, because it certainly wouldn't be fair to anybody, the complainant, the accused, to have to start this trial again.
Mm-hmm. Okay. Criminal defense lawyer Kim Schofield, thank you very much for your time joining us live virtually. We really appreciate it. CP24's crime analyst Steve Ryan joining us live in studio. Thanks a lot.